Have you ever feared losing your job as a result of being injured, especially if that injury was not work-related? This presentation is intended to be a basic introduction to the rights of Canadians with physical limitations in the workplace. My name is Adam Goulet and I'm doing my degree in Human Resource Management at Camosun College in Victoria. I've also been with the Canadian Forces as a reserve medical assistant for the past 14 years, where my duties included handing out physical limitations to individuals who had recently been injured or ill, as well as explaining to both those individuals and their supervisors exactly how their new restrictions would limit them in terms of employability. For the next 5 minutes, we'll be covering three main points: reasonable accommodation, undue hardship, and bona fide occupational requirements. So let's start with your rights as an employee. Reasonable accommodation is defined as the duty to accommodate an individual meaningfully by an employer regardless of their injuries or disabilities. Is this a legal requirement? Yes, absolutely. Sections 2 and 15 of the Canadian Human Rights Act state that employers have a responsibility, a legal responsibility, to accommodate an individual regardless of their needs. Now, what accommodation is required is based on the process of assessing exactly what accommodation should be used. First step there is determining what the barriers are. So for example, if an individual is stuck in a wheelchair, then those 3 steps to get from the street level up to the main entrance to the office building they work in would be considered a barrier. At that point, you have to explore what the different options are of overcoming this barrier, of accommodating for this barrier. For example, installing a ramp, or maybe finding an entrance around a different side of the building that's already at street level. Okay, these are different ways that they can potentially accommodate. Now, at this point, a lot of employers are worried that they might be forced out of business if they have to accommodate someone. Well, not to fear, because this legislation takes that into account as well. Employers are only required to accommodate to the point of undue hardship. Now, undue hardship is defined as the limit beyond which employers are no longer required to accommodate for an individual. There are a number of factors that take this into account, or that are used to determine what undue hardship is, namely health, safety, and cost. Cost being the easiest to sort of choke out as being oh yeah, no, it costs too much, that ramp, I can't afford that. Well, to determine whether or not an employer can afford that, a number of things are taken into consideration, including the size of the company, their profitability, their cash flow, all these kinds of things, whether or not contribute to whether or not they would actually be able to afford putting in a ramp. Now, if it was determined that putting in a ramp would put the company out of business, then that could be used as a reason to claim undue hardship, and therefore the employer would not be required to accommodate for that individual. Now, that being said, as with every rule, there are exceptions and exemptions. The burden of proof to prove that whether or not it was too costly does fall completely on the employer, but also on the employer's shoulders is determining whether or not a particular job has what's called a bona fide occupational requirement. Now, a bona fide occupational requirement is defined as a specific standard or rule that a job has that you need to be able to meet in order to safely and successfully do the job. A perfect example for this is airline pilots. In order to be a pilot of any kind, let alone an airline pilot, you have to have good eyesight. So it doesn't make sense for a blind person or a visually impaired individual to expect accommodation if they wanted to be an airline pilot. Now, that being said, there are a number of there are 3 steps that are taken to determine whether or not something is a bona fide occupational requirement. The first one is to establish a rational connection. For example, eyesight and flying a plane, kind of essential. It's very much an obvious requirement of the job to not only be able to see, but to be able to see well. The second is to make sure that the requirement was established in good faith. So, an independent body set the standard. What is the standard? Why is it required to be 2013 vision and not accepting 2020 vision or something to that effect? And also, why was the standard developed? Was it because, well, a whole bunch of people who couldn't see terribly well in the early days tried flying and crashed a bunch of planes, so that was figure that was probably a bad idea? Or was it a case of, yes, this individual with the limitation has tried, I'm sorry, you need to meet this requirement, and I'm sorry, you just don't. See, that would be considered to have been established in poor faith. So in order for it to be bona fide, you have to establish it in good faith. The third is establishing reasonable necessity. So once you've established that, it's similar to defining whether or not it's reasonable accommodation, where you have to explore the different options. You also have to explore the different options, no matter how silly it may seem initially, to see whether or not there could possibly be some way that an individual who doesn't meet this requirement could still do the job. So in the case of the airline pilot with the visually impaired individual, have they explored using Braille on controls, or having the plane speak all the readings to the individual while they're trying to fly? Things of that nature. And if they've explored all these and can prove that they've explored all of these, and they still determine that no, good eyesight is still required for the safe and successful completion of this job, in that case, you have a bona fide occupational requirement. So now you know, and this basic information about what your rights are in the workplace should you become injured will help you recognize when you or your coworkers, when your rights are possibly being violated. So once again, the points we've covered over the last 5 minutes are reasonable accommodation, undue hardship, and bona fide occupational requirements. For further information on these and other human rights related topics within Canada, you can visit the Canadian Human Rights Commission website and search for Preventing Discrimination. And the website is www.chrc-ccdp.ca. Thank you for listening.